And happy Friday, everyone. It's a gorgeous day here in New York City. I hope you're looking forward to a very nice weekend. Welcome to today's edition of the Friday Call. Marcus is out doing other things right now, so I have the pleasure of kicking off this session. So, folks, we're going to hop into it with Practical Law for Litigation and Arbitration Partners with my guests here in New York. And then we're going to get into an artificial intelligence trend set with Jill and Joe. But first things first, I wanted to point out a couple of things I've used today. I had to make some phone calls. I had to use my card, right? And I also took City Bike to get here. So there's something else that these things have in common, and that they all have binding alternative dispute resolution clauses built into them, right? Like for a City Bike, for example, it's mandatory to go into arbitration for 6 months before you even consider litigation. So I read my terms and conditions this morning to prepare for it. I didn't send them it for analysis because I didn't want to get a bill. But the fact is, arbitration is huge. Over half of in-house counsel, those are the clients that you guys, that your law firms are trying to get their business from. Over half of them respond they have to do arbitrate because it is required by the contract. So it's absolutely huge. So today we're going to talk about Practical Law for Litigation, Arbitration Partners. So Victoria, could you introduce yourself and let us know a little bit about you?
Sure thing. My name is Victoria Kummer. I'm somewhat of a newbie to practical law. I came over in May of this year. I like to say I'm a recovering litigator. I was a commercial litigator here in New York and really around the world through my New York offices for over 20 years. But I retired from practicing law back in 2013. I practiced at Weill Gottschall. I was at a small firm called Bear Marks and Upham, and for the last 12 years, I was a partner at Dickstein Shapiro in business litigation in our New York office. And in addition, I'm an arbitrator. I've been an arbitrator for 17 years. I'm an arbitrator for the AAA, for the ICDR, for the ICC, for CPR, and I'm also a mediator for the Second Circuit Court of Appeals, the Southern District of New York, the commercial part in New York City, and for AAA and ICDR and CPR. And that's enough letters and acronyms for you. Well, I'm also an adjunct professor of law at Cardozo School of Law, where I teach a year-long mandatory first-year course on lawyering skills and legal methods, and I teach an upper-level course on pretrial practice. And that's everything.
So suffice to say, we absolutely have a subject matter expert who is well qualified to talk about this. Litigator, arbitrator, mediator, professor. Are you going to settle down and focus at some point?
Chief cook and bottle washer, that's
okay, all righty. We also have joining us, many of you might know Melissa, but it's been a while, so
yes.
Could you reintroduce yourself?
Sure, I'm Melissa Lorenzo-Herve. I'm an editor on the litigation team and on the arbitration team. I've been with Practical Law for almost 6.5 years now and have been focusing on litigation content for in-house counsel, on record retention, litigation holds, and for the arbitration services, I've been focusing on getting more Latin American content and more U.S. arbitration content, which we've been able to do more recently with Vicky's addition to the team.
Okay. Awesome. And guys, my name is Craig Vaughn. I'm now strategy manager for Practical Law. And we have a special guest here today that was not on the slide. And so what do the 1986 World Series, Seinfeld, and the Society of Epic Mustaches have in common? Well, they have Keith Hernandez in common. So we have Keith joining us here in the New York studio. He's going to have some questions. He'll use the chat function because his laryngitis is kicking in just a little bit. Okay. So first off, why should the folks on the phone be interested in arbitration?
Well, I think the simplest answer is something that you intimated when you first started speaking, which is that all of us are subject to arbitration clauses and may not even know it. For the lawyers out there that you're speaking to, the lawyers' clients all have arbitration clauses, whether they realize it or not. And the fact that arbitration clauses are sort of just routinely contained in contracts these days is only in the past couple of years becoming something that people are aware of. But they've actually been around quite a long time. I think that our arbitration service is probably one of the oldest.
Right.
But it used to be that arbitration clauses were something that you would just put in a contract now and then. But that was 20 years ago. Today, it's routinely put in the contract, and more contracts have them. Big manufacturing and service and production contracts and supply contracts and treaties and, you name it, huge negotiated deals have arbitration clauses, but also your credit cards or city bikes or, whatever it is that you're just using that is bound by a contract in your everyday life will undoubtedly have an arbitration clause.
Right. So you'll arbitrate and you'll like it because the contract says so. But to understand it, they can move along faster. They might be less expensive. So there's some other benefits.
Well, that's the reason that the company started including arbitration clauses in their contracts. The whole idea of arbitration is that it's an alternative to going to court. It's an alternative dispute resolution process. The theory is that, and what it was always supposed to be, is a faster and cheaper alternative to going to court. Yeah. We all know that lawyers' time, billable time, is like gas in a room. It will simply expand to the dimensions of the room. And litigation is one area where that happens more than probably any other. A lawsuit is a death knell to a small company, and it is an enormous hassle, headache, and write-off to a big company. Companies wanted to contain those extraordinary costs. Lawyers are never a profit center at a company. So lawyers the in-house counsel need to contain the litigation costs. And the way they do that is putting arbitration clauses in their contracts, which means if somebody sues me, we don't have to be in court. We have to be in front of an arbitrator or maybe 3 arbitrators, and we get to structure the process. We get to put our arms around it in such a way that it's not going to take forever. It's not going to be 5 years before I ever see my judge or jury, but I'll get right in front of an arbitrator promptly. I'm not going to have explosive discovery that is going to entail airplane flights and hotels and weeks in far-flung lands around the world, but rather the discovery is going to be very contained and it's going to happen quickly. And one of the most attractive things about arbitration is the confidentiality. Unlike a lawsuit where you file a complaint, it's a public document, anybody from the New York Times can take a look at it and see what people are claiming about you. Arbitration is private and confidential. It cannot be disclosed. And nor can the final resolution, the award, can't be disclosed. So you get hit badly at the end of an arbitration and a word comes down in favor of your adversary. At least, it's unfortunate that you're going to have to pay all this money, but it's private. Nobody knows about it unless you have an obligation to disclose in certain public filings.
Faster, cheaper, confidential. Sounds like my online dating life back in the 90s. You mentioned a couple of entities, mentioned arbitration clauses. Melissa, could you let us know what the scope of the service is?
Yes, I love talking about the scope of the arbitration service. Some of you maybe are sick and tired of hearing about it, but it's because you can show the arbitration service to both transactional attorneys and litigators, and that's not the case with most of our services, right? So we have clauses on the arbitration service that the transactional attorneys can use. The drafting notes will help them understand why they should choose one clause over another, why they should draft it a certain way. We have those clauses for every major arbitration institution all over the world. We've covered the main U.S. ones. Those are the 3 ones that U.S. attorneys tend to use for U.S. contracts, the AAA, the CPR, and JAMS. And then we have pretty much every other international arbitration institution included. We have ad hoc arbitration clauses, so that's when you're going to have a clause that says we will arbitrate, but not under the rules of any institution. We'll pick our own guys, we'll figure out the rules later on, we're just saying we're going to arbitrate. And then we update those continuously, and then we have all these practice notes on how to arbitrate under all those different rules from all those institutions. And then we have checklists on how to draft those clauses, of how to make certain filings. Basically, we're trying to mirror everything we prepared for the litigation service, how to run a certain case, well, how to run an arbitration before all of these different institutions. And we have this huge advantage that the UK team has been preparing these resources for so many years, and we've been adding on to that. And then in addition, we have these legal updates that also cover various countries, so that if any rule comes down or an important case or a change in the law in how arbitration is run in several jurisdictions, we have these local law firms writing these legal updates for us that we send out every week or every month according to how that attorney wants to receive them. So it's a very broad service, it's a very deep service, and it's a service that's grown, I want to say exponentially in the past few months, thanks to Vicky and Steve, because they've added so much U.S.-specific content. So if you have a look at the U.S. arbitration toolkit, you'll see how much that's grown. In fact, we now have to pull out several toolkits out of that one toolkit.
So it's technically our most senior U.S. service, if you really want to get technical, because it's been around the UK for a long time before it came here. So, Vicki, what are attorneys using now to get up to speed on things?
You know what they're doing? They're picking the brains of lawyers who know how to do this stuff. That's what they're doing, because there's nothing else out there that is explaining step by step what you do in a AAA arbitration or a JAMS arbitration or a FINRA arbitration or CPR or ICC. There's nothing that provides the know-how, which is what we do. I mean, that's the incredible utility of this. I have to say, when I first came on board at Practical Law and began to get acquainted with the incredible depth of the offerings here in know-how, I was a little ticked off at Dixie Shapiro, because at that time, while I was still practicing, they didn't have it. They do now, but they didn't have it. And it would have saved me an awful lot of unbillable time if they had it. Because what lawyers do now, lawyers will know the substantive law. They're going to know what a claim for fraud is under New York law, or what a claim for breach of contract is under Montana law, or whatever. They're going to know that, and if they don't know that, they're going to go research it on Westlaw, and that's fine. But they're not going to know what the terms of reference in an ICC arbitration are. They're not going to know whether you can make a dispositive motion in a JAMS arbitration. All those technical procedural things, just like you have to learn the court rules when you go to Delaware Chancery Court. You have to learn the rules of the arbitral institution where you're doing an arbitration. And unless you've done it, you don't know it. So where are you going to find it? Practical Law is the only place you're going to find it. Litigators need it, even though they don't need to come to us for what are the elements of fraud in New York. They need it to understand how to actually do the arbitration process. And at the same time, they have available to them resources about all sorts of other things, transactional things, financial statements, whatever. They can inform themselves on the substance of a case that isn't necessarily litigation-oriented, but they need to understand that subject area because the litigation involves that subject area.
Yeah. So you've got procedure that if you break the rules, it's not very forgiving, right? And I know just looking at my Citibank contract, you've got deadlines. You know, you've got 6 months to kick things off or get the case done. So you've got some extra pain points here, right?
Right.
Okay, great.
I have one question, if I can interrupt, coming in on how would a transactional attorney use the service. Basically to look up the clauses. Transactional attorneys insert arbitration clauses in those agreements. For example, a merger agreement, a joint venture agreement, a stock purchase agreement. There can be any agreement between one company and another that says if anything goes wrong related to this contract, we're not going to court, we're going to go to arbitration. And so transactional attorneys, they're massaging all those different clauses, they're figuring out what they can negotiate with the other side. One of the clauses that they have to sometimes draft, sometimes they copy and paste, and that ends up in other types of trouble is the arbitration clause. And so if they can go and use our drafting notes when they're preparing that clause, they'll draft a better clause. They'll be able to protect their client more. In some cases, they actually have to go to the litigator if they know and say, you've arbitrated AAA, or you know what clause I have to insert here. Here's the contract. Figure out which clause I should insert. They can advise their client much more thoroughly if they can explain why they inserted a AAA clause or why they inserted an ICC clause, which we have with drafting notes.
And a good clause can be a thankless task until something goes wrong.
Exactly.
Right.
When it goes wrong, guess whose fault it is?
Exactly.
Right, yeah, the transactional attorney putting it together.
Right.
Right, yeah. Okay, great. So what do, this came in from Keith. What do the Mets need to do to beat the Cubs?
Pray.
Okay.
Pray a lot, and, hope that David Wright and Lucas Duda, get their groove in.
Yeah. Okay. So we talked about who else needs arbitration. You've got transactional attorneys, the litigators, all the attorneys are going to need to do it. So it really has mass appeal to a lot of the folks that you've already been talking to.
Put it this way: any lawyer who has a client needs to understand arbitration.
There you go.
That'd be a lot of them. I think. Okay.
More than a handful.
So let's focus on the partners. What we're going to do is hop over to the site and just walk through a couple of typical use cases where practical law would have been helped you, who could frankly who does write all of this stuff.
Yeah.
How could something like this help you out?
All right. Here's an example where I was litigating a case that actually the case itself was not in arbitration. This is just how practical law is helpful to a litigator, period, whether they're in court or arbitration or where.
Let me stop. In case somebody's calling in, I have on screen right now the preferred stock overview. Sorry about that, in case somebody's not watching, they're listening.
Right.
Sorry.
Okay. So when a litigator is taking on a case, you're going to have to understand certain substantive issues in the case, separate and apart from the procedural stuff. Yes, I have to understand what the procedure is in this particular court, but there are many times, at least in the sophisticated commercial litigation that big law often is involved in, there are substantive issues that are not your nuts and bolts, breach of contract, fraud, whatever. So I had a case where it was out in Seattle. I was representing some limited partners in a claim for a forced redemption of some limited partnership interests in a timber company. And I had a senior associate working with me. The damages in that case were understandably pretty complicated for a forced redemption. There was all this damage modeling that really had to get, clarified about how it is that you're going to go about doing a valuation on something that doesn't actually exist. So it's sort of heady stuff. And there were experts, tons of experts on each side. Well, the senior associate I had working on the damages aspect of the case with me, she needed to understand these concepts. And she had not intersected with any of these concepts before. She could go get a preliminary injunction somewhere for a breach of a contract. She could litigate an employment case, but she had never run into this kind of damage modeling before. So I ended up having to bring her with me for a series of depositions that I had to take out in San Francisco and Portland, Oregon for a couple of weeks, because I was taking the depositions of, I was defending a bunch of depositions of our experts. And she needed to understand from those experts these concepts so that she could then go back to New York and help me prepare and put together the exhibits and everything for the depositions that I would be taking of the other side's experts. Here's the point. She could have avoided that whole expensive series of trips out to the West Coast and the tutorials by our experts and stayed in New York and learned these concepts just by accessing practical law, so that I could be out doing what I needed to do on the West Coast, and she could be preparing the stuff that I needed In New York, had she just gone to, for example, preferred stock overview? Has she had gone and just typed into the query line the word redemption? That would have brought her to this preferred stock overview. You know, you can get into it a few other ways. You could also type appraisal of a business or waterfall provision.
I preloaded it.
Okay. but these you know, sort of keywords would have immediately gotten her to the corporate and M&A pages that had substantive information to educate her. So basically, she could have given herself a tutorial on these concepts. Now, what that means is, it doesn't mean that my firm would have lost those billable hours that she spent out on the West Coast. In fact, what it means is that we would have had more billable hours, because I had to write off a lot of her time.
Got stuck twice.
Yes. I had to write off a lot of her time when she was out on the West Coast with me, because I can't really charge the client for her getting up to speed time. But in addition, we would have had more time, billable substantive time, hit the ground running sooner on the preparation for the adversary depositions. Had she been able to give herself a practical law tutorial on these concepts back in New York while I was out on the West Coast doing what I was doing. So, I mean, that was just like one example that popped right into my head once I started to get better acquainted with the Practical Law website. I was like, oh my God, we could have been so much more efficient litigating that case.
And so, like, you know, big value prop, you know, we use the training angle and whatnot, but even like smaller firms that maybe don't have a lot of associates, that still have a lot of partners, they still have to disseminate their own expertise to both either their associates or people working on the transactional side, or people, or even their clients. And a lot of these questions that especially an associate would have, you don't want to spend your time answering those questions. Those answers are here.
Those answers are there. And, you know, another example of eliminating non-billable time and therefore freeing me up for billable stuff, I had a partner out in California, and this is just one of many examples of this. This partner had a beauty contest. He was going in to pitch a client who had a whole bunch of arbitration clauses in their contracts with various subsidiary distributees. And it called for ICC arbitration. So the partner was going to have to be able to talk knowledgeably to this client about ICC arbitration, and he didn't know anything about it, of course. So he calls me up, and what I think is going to be, you know, maybe a half an hour conversation turns into 2 hours of my time explaining all of this stuff to him. He had never done an arbitration. He didn't know the first thing about it. So really, really basic stuff, and then building up to a little bit more detail, a little more detail. You know, he had certain questions that he knew the client was going to have that he wanted to be able to answer about, you know, whether la Cour International Arbitration does a recognition of competence when there's an appeal happening. You know, I mean, these kind of sort of hyper-technical things. All of this stuff. He could have just gone to the Practical Law website, educated himself, leave me out of it until they're ready to arbitrate something so that I can be doing my billable work instead of answering his silly questions. It just makes sense.
Yeah, and I'm sitting here thinking, I mean, I don't know how much you charge per hour and how much this guy charged per hour, but if you can save each other several hours, that's the one matter. That's
one phone call.
That's less than the subscription for the year.
A couple of $1,000. One phone call.
One phone call, right.
And that's something we don't talk a lot about, right? We talk about the associate going to the partner and the partner dealing with the associate.
Yeah.
No, partners and partners, wasting time, calling each other. What do you know about this? How do I answer this question from the client? Both wasting time. Maybe one can bill it, but both can't.
Yeah, right.
Subscription paid for itself right there.
Right.
And the client was answered more quickly.
Right. You know, whenever somebody in either a big or a small firm, whenever some new thing comes in the door, some new motion they're going to have to deal with, whatever, first thing they do, they send out an ISO, in search of, an email blast to everybody in the firm who's litigated a TRO and preliminary injunction in Iowa. And, of course, what you get back is 10 years old and out of Florida. I mean, it's just completely useless. So you have to, even if it's out of Iowa, 10 years old. And so you always have to dust it off and figure it out, whether or not this is even applicable, or then do your own research. What practical law gives you is an army of people who have already done that. They've already dusted it off. They've already kept it up to date. They've already made it specific to a jurisdiction. And who has done it is not some junior associate, who couldn't get a job somewhere else. It's former partners at a big law firm. That's who did it. And it was updated as of a couple of months ago. So it is saving inordinate time and money right there every time you're tempted to do an ISO.
Fantastic. So I think that really paints a great picture about how painful this can be and how the practice can be and how beneficial the service is. We've got a couple of questions I want to get to, but just to kind of cut through a couple of things because we need to let the other folks come on in 3 minutes. Okay, so great. You understand that this is wonderful stuff. What do you show? Guys, the toolkits, let me back up a little bit. Those entities that they mentioned, they're all over here.
Right.
This is inclusive. I mean, the topic is international arbitration. This is inclusive of domestic arbitration. So don't think, where's all the U.S.
Yeah, it includes U.S.
It's all right here. These toolkits right here, fantastic way. You can do a mic drop type of a demo just by showing these off.
Right.
I understand that the updates are substantial.
Extremely popular because there's nowhere else you can go to receive updates on how the arbitration law has changed in all of these jurisdictions that we cover.
Real-time updates.
Yeah.
Right.
Yeah. So you can't get it anywhere else. Okay, so a couple of questions coming in.
Besides Go Cubs.
Yeah. What does practical law have for international arbitration? Well, we just talked about that. If arbitration awards are confidential, what is the source of the award on Westlaw?
Now, right, we wanted to go into that. First of all, not every single award is confidential, right? There are FINRA awards. FINRA, they have to be public.
Yeah.
There are also ICSID awards. Those are public because they're between governments, and as soon as they're published, anyone can see them online, not even on a specific site. You can go to the ICSID site. Other companies will cover them. And then you can fill this in a little bit, but sometimes someone will attach an award to a court filing.
Yes.
And to be able to do that, that original award was not confidential.
Right.
And so Westlaw people are going into the court filings and seeing where has an arbitration award been attached to some other filing, maybe to motion to confirm an award, and then they pull it from there. That's why it's such a limited amount of awards.
Right. It's a tiny fractional subset of the awards out there.
Okay, great. Well, so let's
and the names of the parties are often redacted.
Yeah, okay. All right. Anything else before we hand it over?
Flowcharts.
Any more?
Oh, the flowcharts that we have for all the different institutions.
Flowcharts are very popular.
Right. So if you're talking to partners, especially litigation partners, you want to show those flowcharts because that helps them understand if I'm arbitrating before this organization,
right?
This is what this looks like. If you're going to read a practice note, that's going to take some time. It's going to answer a lot of questions. But here you have a very succinct visual, right? A picture of how it works, what are the rules, what is the order of everything, and then maybe you're really good at AAA or you have a lot of experience with ICC. If you pull up a chart for another institution that you're not familiar with, you can quickly see how it's different, how it's similar.
And if you've never been in that institution before, you're basically a first year.
Right.
So guys, all you have to do is just search for flowcharts and pre-filter arbitration, and just wait for the fireworks.
Right. And we have a few more coming because Vicki has been spending a lot of time the past few weeks preparing more flowcharts. And if I could just go back to that international arbitration content question, if you click on jurisdictions when you're in the international arbitration service, it's in fact the only service that has that third tab, browse by country. On Westlaw, I think it says jurisdictions or browse by country. You'll see all of these different countries that we cover. If you want to see additional countries, you click there on that blue tab that says more countries, and you'll see everything we have on arbitration for all of those jurisdictions. And we also have country Q&A. So similar to our state Q&As, we have country Q&As for all of these various countries' arbitration laws. We also have various practice notes on how to enforce an arbitration award in those countries. So it's actually a very, very broad service when it comes to the international content, broader than any other service.
Okay. Thank you both so much.
Thank you for
really
having us.
Appreciate your time. Jill and Joe, you are on deck.